This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So we often talk about the difference between a concept that is not copyrightable and the expression that is copyrightable. So pardon me if I'm a little surprised that there even was a lawsuit over the concept of putting comedians in a car and shooting the shit while drinking coffee. Well, that's what the lawsuit's about. This is Christian Charles versus Jerry Seinfeld. Now, this is the Second Circuit's appeal decision. They say the same thing I do. Comedians in cars does not infringe on anything. Let's take a look at the Second Circuit's opinion, and then we'll go over here and look at the district court's opinion that they're affirming. So we're going backwards on this one. Appellant Christian Charles appeals from the September 30th, 2019 judgment of the United States District Court for the Southern District of New York, granting defendant's motion to dismiss on grounds that Charles's copyright infringement claims are time barred. So you didn't sue quick enough. You sued too late. In February 2018, Charles sued comedian Jerry Seinfeld and other defendants in a copyright infringement action based on his claimed authorship of the television series Comedians in Cars Getting Coffee, a show whose pilot episode Charles and his production company helped develop in 2011. So at least there's the connection. It's not just some random person who's like, no, I own that. They had an involvement in the production. To maintain an action for copyright infringement, a plaintiff must establish 1, ownership of a valid copyright, and 2, copying of constituent elements of the work that are original. Claims must be brought within 3 years after the claim has accrued. When ownership is the dispositive issue in an infringement case and the ownership claim is time barred, the infringement claim itself is also time barred, even if any allegedly infringing activity occurred within the limitations period. An ownership claim accrues only once, when a reasonably diligent plaintiff would have discovered that ownership was disputed. We conclude that the district court was correct in granting defendant's motion to dismiss for substantially the same reasons that it set out in its well-reasoned opinion. The dispositive issue in this case is whether Charles' alleged contributions qualify him as the author and therefore owner of the copyrights to the show. Charles disputes that his claim centers on ownership, but that argument is seriously undermined by his statements in various filings throughout this litigation, which consistently assert that ownership is the central question. To take one example, the memorandum, in opposition to defendant's motion to dismiss, stated that resolution of this case depends upon the answer to one simple question: who is the author of the pilot? As the district court explained, authorship is merely one path to ownership of a copyright. Charles asserts that he owns a copyright in the pilot episode of the show because he is its author. Seinfeld disputes that claim, contending that he conceived the show and that Charles did his work as a hired producer and director. Therefore, the central issue is clearly a dispute over ownership, as opposed to a dispute over whether subsequent iterations of the show make use of the material in the script for the pilot. Charles's infringement claim is therefore time barred because his ownership claim is time barred. The district court identified 2 events described in the Second Amendment complaint that would put a reasonably diligent plaintiff on notice that his ownership claims were disputed. First, in February 2012, Seinfeld rejected Charles' request for back-end compensation and made it clear that Charles' involvement would be limited to a work-for-hire basis. Second, the show premiered in July 2012 without crediting Charles, at which point his ownership claim was publicly repudiated. Either one of these developments was enough to place Charles on notice that his ownership claim was disputed, and therefore, this action, filed 6 years later, was brought too late. We have considered the remainder of his arguments and find them to be without merits, and the judgment of the district court is hereby affirmed. So let's see, what did the district court have to say about that? So this is Judge Allison J. Nathan. This litigation concerns allegations that plaintiff is the author of Comedians in Cars Getting Coffee, produced and distributed by defendants Jerry Seinfeld. Now, before the court is defendant's motion to dismiss. For the reasons set forth below, the court grants the motion to dismiss. The copyright claims are time barred, and the court declines supplemental jurisdiction over state law claims. So there are apparently some other claims. There's state law claims. You can bring state law claims in federal court if you have a primary federal court claim first, and then have some connected ancillary state law claims. Sometimes you use the federal claim to get you into court in federal court so that you don't have to adjudicate the state court claims separately in state court. Since the 1990s, plaintiff Christian Charles, a writer and director, and defendant Jerry Seinfeld, a well-known comedian and actor, had worked together on various projects. During one of their collaborations, Charles allegedly suggested to Seinfeld that he could create a television show based on the concept of two friends talking and driving. Charles produced a treatment of the show, but Seinfeld ultimately decided not to proceed with the project. Treatment commonly refers to a brief outline in prose describing the actions of a movie plot, indicating characters along the way with little or no dialogue, running no more than 25 pages. It can include a mixture of story and staging. Really? You're going to put the one word of the footnote on the next page? Come on. Seinfeld allegedly mentioned to Charles in 2011 that he was considering a talk show about comedians driving in a car to a coffee place and just chatting as his next project. Charles claims he immediately noted this was the same idea for which he earlier produced the treatment. Then they purportedly agreed to work together on the project. Charles then produced a new treatment which he claims captures the look and feel of the cars getting coffee concept. Seinfeld liked the treatment, and Charles allegedly created a synopsis, a camera shot list with description and visual camera angles and script, all of which he calls the script. October 2011, Charles and his production company, Mouse Roar, shot a pilot of the episode with Seinfeld, settling on the name Comedians in Cars Getting Coffee. According to the Second Amended complaint, despite some initial reservations, Seinfeld decided he wanted to proceed with the project. In Charles's telling, this is the point where things go sour. Charles allegedly had a business understanding with Seinfeld that Mouse Roar would provide all production services and was concerned when Seinfeld brought in a subsidiary of Sony Pictures Television that also did production work. In January and February of 2012, Charles claims that he communicated his request for compensation and back-end involvement with the show. According to the Second Amended complaint, Seinfeld expressed outrage at the notion that Charles would have more than a work-for-hire directing role. The Second Amended complaint further states that Seinfeld characterized Charles as ungrateful and told Charles that he should expect to be compensated through his directing fee. They had another conversation along similar lines a few days later. During these conversations, Charles alleges that Seinfeld did not claim authorship or ownership of the pilot, even though Charles had reminded Seinfeld often that the idea for the show was Charles's. Charles also contends that he never made any agreements with any of the defendants regarding a work-for-hire arrangement or his alleged copyright interests. Now, he is supposed to have a written work-for-hire arrangement. And so if he had brought a work-for-hire claim, of the ownership claim within 3 years, maybe he would have had a case if there really was no written work-for-hire agreement. Let's take a look, actually. Let's take a quick look at what the work-for-hire guidance is from the U.S. Copyright Office. A work made for hire must be a work prepared by an employee within the scope of his or her employment. Directors usually do not work for W-2 employee wages. They're usually contracted. So they would be under this B section, a work specifically ordered or commissioned for use as part of a larger audiovisual work or motion picture. If, big if down here, if the parties expressly agree in a written instrument signed by them that it shall be a work for hire. So this came up in the Alex Mauer Imago Softworks case, the StarMazer DSP case. You had to have a work for hire arrangement in writing, which Imagos did have, and that became the contest, basically. Was that valid or not? And it turned out to be valid enough to convince Alex to sign a release of claims, basically a release of not only the claims, but turning over her works. Charles alleges that business partners and confidants of Seinfeld assured Charles that he would remain involved and that the spat with Seinfeld would blow over. As late as April of 2012, Charles claims that one Seinfeld representative left a voicemail stating that they could still work together. Later that month, he says Seinfeld agreed to pay $107,000 for pre-production expenses that Mouse Roar incurred. Charles also alleges that he and his representatives were engaged in discussions with Sony regarding a potential deal and back-end compensation as the show's writer and director. Despite these conversations, Charles had no further involvement in the project, which became a successful web series that continues to produce new episodes. From 2012 to 2014, Charles claims that he maintained a reasonable and good faith belief that Seinfeld would eventually acknowledge his authorship and ownership and bring him in on the show. So that's maybe how it happened. Maybe how he got past 3 years was because he didn't think that he had to bring a claim then. He thought that he would eventually be brought back in. He was Rey from Star Wars, hoping that her family would come back and save her, and her life would completely change. I mean, we can all kind of identify with that in some way. Like, all of us has longed for something that was unrealistic at some point in our lives. If you've lived, you've probably made the mistake of hoping for something that was never going to happen. That month, Charles registered his treatment with the Copyright Office. In 2017, Netflix inked a lucrative new deal for the show to join their platform, leading Charles to contact Seinfeld. Seinfeld's lawyer responded, stating that Seinfeld was the creator and owner of the show. While Charles concedes that Seinfeld had previously claimed to be the creator of the show in the press, this was the first time that any Seinfeld representative had directly made this claim to Charles. In February of 2018, Charles filed this lawsuit against defendants, all of whom were involved in the production or distribution of Comedians in Cars Getting Coffee. He brings claims for copyright infringement of the treatment, script, pilot, as well as claims for joint authorship, injunctive relief, and several state law causes. So we know what the motion to dismiss standard is. A complaint must contain factual matter sufficient, accepted as true, that states a claim to relief that is plausible on its face, and that claim to relief must be legal relief, must be something the court can actually grant. Defendants argue that plaintiffs' copyright claims are time-barred. The court agrees. Civil actions under the Copyright Act have a 3-year statute of limitations. Now, so if I make a copyright infringement of your work and I put it up on YouTube and it's displaying every day on YouTube, and 3 years goes by, on the third year and first day, do I suddenly own something that I didn't own before? No. Maybe the claims from 3 years and 1 day ago or 3 years ago are time barred, but if I'm still releasing every day, if I've still had that video published and it's infringing, then you still have a current copyright infringement claim. But if I published it once 3 years and 1 day ago and then never published it again, now I'm in the clear. To successfully sue for copyright infringement, a plaintiff must show ownership of a valid copyright and copying of constituent elements that are original. The Second Circuit has held that when ownership is the dispositive issue, the major and disposing issue of the case, in an infringement claim, and the ownership claim is time barred, then the infringement claim itself is time barred, even if there had been infringing activity in the 3 years preceding the lawsuit. Plaintiff's infringement claim is squarely rooted in his contested assertion of an ownership interest in the copyright. The principal issue in this case is not the nature, extent, or scope of copying. Rather, it is whether the alleged contributions of Charles qualify him as the author and therefore owner of the copyrights. Plaintiff does not truly dispute any of this. Instead, plaintiff makes unavailing attempts to distinguish Second Circuit precedent on this issue. First, he contends that this lawsuit is about authorship, which is somehow different than ownership. However, authorship is merely one path to ownership of a copyright, and the Kwan case itself dealt with an authorship dispute. Second, plaintiff argues that the Kwan case and the Simmons case involve disputes over plaintiff's status as an owner but not defendant's status. This is not a material distinction because a non-owner defendant can prevail in an infringement suit so long as the plaintiff is also not the owner. Moreover, the plaintiff in Kwan claimed that she and not the defendant was the sole author, even though the defendant had been listed as the author on the work in question. This set of facts largely mirrors the present case. Having determined that ownership forms the backbone of the infringement claim, the relevant inquiry is whether it is evident from the face of plaintiff's second amended complaint that his ownership claim is time-barred. So in other words, we're on a motion to dismiss here. We haven't gone through discovery, we haven't gone through trial, nobody's testified. The ownership claim accrues only once, when a reasonably diligent plaintiff would have been put on inquiry notice that they needed to make an inquiry as to the existence of a right or copyright. Furthermore, any number of events can trigger the accrual of an ownership claim, including an express assertion of sole authorship or ownership. For several reasons, the Second Amendment complaint describes assertions made over 3 years before this lawsuit was filed that were sufficiently express as to put a reasonably diligent plaintiff on inquiry. First, the complaint alleges that in 2011, Seinfeld twice rejected Charles's request for back-end compensation and made it clear that Charles's only involvement was to be a work-for-hire. Seinfeld restricting Charles to a work-for-hire directing role necessarily contradicted any idea that Charles was the owner of intellectual property in the show. Even if all of the inferences are drawn in favor of Charles, that's the motion to dismiss standard, a reasonably diligent plaintiff would have understood that Seinfeld was repudiating any claim of ownership that Charles may have. That Seinfeld did not expressly claim ownership for himself during these conversations does not matter. It is sufficient that Charles's claim was rejected. Charles claims that statements made by associates of Seinfeld in the aftermath of the 2 phone calls diluted or muddled that repudiation. However, the complaint makes explicit that these complaints relate only to whether Charles would remain involved in the project. It's not over. Christian and Jerry can still work together. Even drawing all inferences in favor of Charles, these remarks do not plausibly contradict Seinfeld's statements that Charles would not be involved on more than a work-for-hire basis. Second, Seinfeld and the other defendants went on to produce and distribute the show without giving any credit to Charles. In Quan, the fact that the book in question was published without crediting plaintiff as an author was enough to put her on notice that her claim of authorship was repudiated. As the complaint states, from 2012 to 2014, Charles believed that Seinfeld would eventually acknowledge Charles's authorship and ownership and bring him in on the project. Even interpreting the complaint most favorably to Charles, it clearly alleges that he was aware that the show was being produced and that he was not being credited on it. Because he was on notice of his ownership claim, which had been repudiated since at least 2012, his infringement claim is time-barred. His joint ownership claim is time-barred for the same reasons. And his request for an injunction fails because it was premised on his assertion that he is the sole owner. Because Charles has had multiple opportunities to amend his complaint in the face of defendants' timeliness arguments and has not made any further amended requests, these claims are dismissed with prejudice. The court further declines supplemental jurisdiction over the remaining state law claims. That makes sense. The court finds no reason to deviate from normal practices here. The court has not yet invested resources necessary to resolve these claims, and because the extensive discovery already taken is likely sufficient to enable these claims to be evaluated in state court without any additional discovery, the court declines to exercise supplemental jurisdiction, and they are dismissed without prejudice. After submitting briefing on this motion, the parties became engaged in a dispute regarding the proper procedural vehicle for defendants to challenge plaintiff's attachment of various declarations and affidavits to its opposition memorandum. Because these declarations and affidavits would not affect the course analysis, the court declines to address that too. So apparently there was extensive discovery, there was testimony, and there was production of documents. For the reasons stated above, the court hereby grants defendants' motion to dismiss. The federal claims are dismissed with prejudice. The state law claims are dismissed without prejudice. Because the court resolves these motions on the papers, defendant's request for oral argument is denied. The clerk of court is directed to terminate the docket numbers in this case and close the case. And that was September 30th, 2019, which of course we saw was just affirmed by the Second Circuit Court of Appeals. So that was the challenge to ownership of comedians in cars getting coffee. It almost sounds like it was a valid challenge because the work for hire agreement wasn't in writing, although that was up for dispute. It sounds like maybe there was some writing that went back and forth, and maybe something there might have become effectively the writing required by the law. But if there was no writing, then it was not a work for hire if it was by a contractor. So Charles probably had a valid claim and just needed to bring it within the 3 years. Or at least Charles could have had a valid claim, but he didn't bring it within 3 years. Let us know what you think in the comments below. And rest in peace, Jerry Stiller. He's a great actor and a great comedian, and I did enjoy lots and lots of Seinfeld back in the day. My personal way of enjoying Seinfeld was in the commons area of one of the student halls where they had pool tables at the University of Delaware. And when it was finals time, I would go and study for finals and play pool and watch Seinfeld. I probably did more pool playing and Seinfeld watching than I did studying, but that's why I'm a lawyer and not the electrical engineer that I started out to be. So there's a reason to study for you. Don't neglect your schooling. I got my second chance, passed law school with flying colors, but not electrical engineering school. No. Ended up with an IT degree because math. IT does not involve math, but electrical engineering involves lots of math. So maybe I'll finish that someday. Maybe I'll be one of those 62-year-old people who finishes their electrical engineering degree. We'll see. So that is our show. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube. Thank you very much to all of you who support us financially on a month-to-month basis, or even just incidentally, but the month-to-month supporters get the benefit of being shouted out here and getting put on my LED panel back there. The $50 plus supporters for May on patreon.com/ljfrench and sponsors.com/law are Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Ottah, Cute Grills in your area, Longreach Jones, Zachary Chaney, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. And the $5 plus supporters and everybody who's $5 plus appears in the description of the video and on that LED matrix panel. So anyway, I love you all. Have a great week. I'll see you in the videos that drop. Thank you for joining me. Bye.